Welcome back. Parliament's Legal Services has informed the Portfolio Committee on Land Reform and Rural Development that the chairperson of the Ingonyama Trust acted beyond the scope of his powers when he suspended some board members from that board. Now, King Misuzulu is the chairperson of the board. His decision was overturned by the minister, who argued that he had the powers. Now, for more insight and understanding the Ingonyama Trust, I am joined by Dr Aninka Claassens, the Chief Researcher for Land and Accountability, at the Research Centre at the University of Cape Town. Doctor, thank you so much for your time and for joining us this evening. Now, let's perhaps begin with you just providing an overview of the Ingonyama Trust and its role in land management in KwaZulu-Natal. What was the original purpose of this trust when it was established?
Well, originally it had a very political purpose. It was a deal that was struck between the outgoing National Party and former Chief Minister Buthelezi. And it was only on the basis of this deal that the Inkatha Freedom Party agreed to participate in the 1994 elections. And basically, what happened was that an act was enacted by the KZN Parliament just before the change of government in 1994. And that act provided for a trust headed by the Zulu King to hold the land of the former KwaZulu homeland. But the act was very explicit that the King's powers were fiduciary powers, and they could not undermine any pre-existing or coexisting rights vesting in the people who live on the land, and that the people who live on the land are the beneficiaries of that trust. And it provided that the income from the trust, 90% of the income from the trust, must be spent on the beneficiaries. But over time, the trust has been reinterpreted primarily by the former chair of the trust board, former Judge Jerome Ngwenya, as a vehicle owned by the King. And he posited a view that the land belongs to the King and all the income from the land should go to the King. Now, that has been hotly disputed since at least 2009, when the trust started to get adverse audits in Parliament, by the Auditor General, and when the trust in particular started to try to lease out land to the very people who owned it according to customary law. And that culminated in a court judgment in 2021, which was a full court of the Natal KwaZulu Division, headed by Judge President Madondo. And he said at the time that, of course, customary law provides that the beneficiaries are the owner of the land because they have customary ownership of the land. And that builds on an earlier constitutional court judgment, the Alex Court judgment in 2004, where the Constitutional Court found that customary ownership is not akin to Western ownership. It's not like Western ownership. It is ownership. So that ownership vests in the people with customary rights. It doesn't vest in the King. But there was this misperception created by the previous trust board that the land belongs to the King outright and the proceeds belong to the King outright. And that started a situation where the proceeds began to be used as a source of a separate purse for the previous King and now the current King to spend on legal fees, to spend on expensive vehicles. And that's completely contrary to the terms of the Act, which says that 90% of the proceeds must be spent on the beneficiaries. And, you know, the Portfolio Committee, for a number of years now, has been desperately trying to ensure some sort of accountability. And finally, the previous Minister of Land Affairs, after initially supporting the Ingonyama Trust Board in their in their rent seeking, where they were actually extorting money from the owners of the land for their own, for the king, actually. You know, basically that judgment put it beyond doubt that this, that the people living on the land are the owners of the land, but it had become complete common practice by then that the trust's finances have been used as a kind of honeypot by whoever the current king is. And I think, you know, there's major misperceptions with a lot of people thinking that the king owns the land and the king owns the money. And maybe the king himself believes that. But that's not what the Act says.
Right. And I want us, Doc, maybe just to get into those misconceptions and why they are there. I mean, you speak about rent seeking and the beneficiaries being the owners of the land, and 90% of that income is meant to be going to those beneficiaries. Is there sufficient education for the beneficiaries of the Ingonyama Trust for them to know and understand what their rights are when it comes to that piece of land?
No, there isn't. You know, the previous chair of the board, this former Judge Ngwenya, he actually insisted that people's old permit-based rights, which actually can be upgraded to ownership, so they're very strong, although they're called permission to occupy certificates, he insisted that those be cancelled and instead people take out the leases. And his explanation was, the king owns the land, and if you don't take out a lease, which commits you to paying for that land and provides that if you don't pay at a 10% increase per year, then the land can be removed from you. People were extorted to take out those leases on the basis that they were told that if you don't, you'll have no security of tenure and you can be deprived of this land. So there's been this massive misinformation, and unfortunately, there's never been a proper education program to rectify that. I mean, you've got the judgment, which now says that all of that money that was collected must be repaid to people, and you had the minister putting in a new board that tried to get some kind of financial accountability. And those are the people whom the new king has actually tried to fire, although, as the Portfolio Committee's legal advisor has said, he doesn't have the power to do that. That power vests in the minister after consultation with the king.
So in your view, in what ways has the trust contributed to or hindered economic development in the regions that it oversees?
It's been a terrible drain on economic development. It has insisted that any revenue from development gets paid to it, and it has refused to account for that money to Parliament. So, you know, even rentals from, you know, Vodacom towers on communal land have gone straight into the central honeypot and not been accounted for. And, you know, there is evidence of, you know, large amounts of money being spent on vehicles for the king, the previous king, and now the new king is using that money to pay for legal fees, completely at odds with the terms of the law governing the trust. You know, I think the best analogy is that the king is the trustee of that land in the same way as the Minister of Land Affairs is the trustee for all the land in the other former homeland areas. That doesn't give him ownership of that land.
Right.
He has a position as minister. The king has a position as king, but it's a trusteeship position. He's got fiduciary duties to all those people. But, you know, the confusion goes back to the very beginning and the political purpose of this act, which was a compromise in order to bring Inkatha into the 1994 elections. And that compromise was based on a whole lot of false assumptions that this would give the king ownership of the land. So in a way, there's always been an incredible misfit between the terms of the law, which are clear-cut, that the trusteeship is subject to people's pre-existing rights, and the way in which it has been sold to people, which is, oh, it's only the Zulu nation who have a king who owns their land, different from any other group, Xhosa, Venda, Tsonga, whatever. Whereas the same arrangement basically exists, except that in their case, the minister is the nominal trustee, but that doesn't give him ownership of that land at all.
It certainly doesn't. So, Doc, now the Land Expropriation Act has caused an uproar among some communities in South Africa. Would land under this trust be affected by this piece of legislation? And what would the impact thereof be to those communities? And how involved in decision-making regarding land use as well as management under the Ingonyama Trust are these communities?
Yeah, I'm sorry about that. I don't think the Expropriation Act will have any impact because in order to avoid paying rates, the Ingonyama Trust under former Judge Ngwenya argued that the land is in fact state-owned. And in fact, it is nominally state-owned, but it is subject to people's customary rights. So they conceded that the king doesn't own it and that it's state-owned. Now, the state can't expropriate land from itself. So the Expropriation Act is not a threat. What could be expropriated are people's rights to the land. And there we have a law that would protect people, which is the Interim Protection of Informal Land Rights Act, which provides that nobody can be deprived of an informal right. In other words, a right that might be strong in law but is not written down. It's not strong in terms of record keeping, like customary law. They may not be deprived of that without their consent. And that's been upheld in the Maledu judgment of the Constitutional Court in 2018. So the expropriation is no threat. The Expropriation Act is no threat to people living on Ingonyama Trust land or any kind of land within the former homelands. They all fit into the same category, where actually, legally, until customary rights are formalized and given proper recorded proof of their status, the land is nominally owned by the state, but it is subject to their customary ownership of the land. Right. So, yeah, the Expropriation Act is a red herring in this context, complete red herring.
All right. Thank you so much, Dr. Claassens, for that clarification. We certainly do appreciate your time this evening. That's Dr. Aninka Claassens, the Chief Researcher, Land and Accountability at the Research Centre in the University of Cape Town.